Hey guys, today we are going to talk about discovery in the legal court proceedings. Now, what is discovery? Discovery is a stage of the lawsuit process whereby each party is required to disclose to the other party all the documents that they have that are relevant to the issues in the lawsuit. This is regardless of whether the documents support your case, they are good for you, and regardless of whether the documents are bad for you. So even if the document does not support your case, it attacks your own case, you have to disclose it. And not only do you have to disclose it in the list of documents, but the other party has the right to inspect the documents that are being disclosed. In the past, there used to be physical inspection, but nowadays it's all done by email. The lawyers will usually send a zip file containing all the documents in PDF to the other lawyer for inspection. Some people may then ask, oh, do I have to disclose all my documents? The answer is no. The general position is that discovery or disclosure of documents is limited to documents that are related or relevant to the matters in question in the lawsuit. What is related or relevant? The case of the Peruvian guano company sets out the principles under which a document is considered relevant and has to be disclosed. Number one, the document tends to prove or disprove a matter in issue between the parties. So if the issue is whether there is a contract, then if there is an email or a WhatsApp message to show unequivocally that one of the parties had said, yes, I agree to all the terms, that email or WhatsApp message will prove the existence of the contract because that is the issue. In the case of disproving a matter in issue between the parties, for example, one of the issues, could be a director alleged siphoning off of money to some third-party company or entity. So one of the party alleges that the director, in breach of his duties to the company, siphoned off the money. But the other party has a payment voucher, an invoice, or whatever, which will disprove this allegation that he siphoned off the money. So that invoice, payment voucher, or delivery order would disprove a matter that is in dispute between the parties. The second principle laid down in the Peruvian guano case is that a document is relevant and has to be disclosed if it enables one party either to advance his or her case or to damage the case of his other party. The third principle laid down in the Peruvian guano case is that a document has to be disclosed if this document may fairly lead to a train of inquiry. So that means, what this means is that if you disclose this document, it will lead to a train of inquiries leading to other documents. Order 24, Rule 1 of the Rules of Court states that a party is required to disclose documents which the party relies or will rely on. Number 2, documents which could adversely affect his own case. That means it's bad for him. Or adversely affect another person's case. That means it's bad for the other person. Or support another person's case. Now, the failure of a party in a lawsuit to produce evidence in the discovery process may give rise to an inference, an assumption that it is unfavorable to him, it's not good for him. Under Order 24, Rule 16 of the Rules of Court, if a party in a lawsuit fails to comply with the discovery obligations or to produce any documents for the purposes of inspection or for any other person, then the court may order the claim to be struck out. Struck out, that means cancelled, Or the court also has the power to enter judgment. That means the other party wins. In the Singapore cases of Case Solutions and National University of Singapore and Alliance Management SA and Pendleton, the court ordered the claim to be struck out, to be cancelled because of the deliberate destruction. They shredded or burned or destroyed the document, or suppressed. That means don't disclose. Documents which had to be disclosed did not comply with their disclosure obligations under the rules of court. Discovery is essentially the lawyers have to prepare a list of documents. It's a list in table form. The first column is a serial number. Second column will be the title of the document. For example, loan agreement, okay, or WhatsApp message or email dated, whatever. The third column would be the date of the document. And so the lawyers have to compile a list of documents that were in the parties' possession, custody, or power. And then the list of documents has to be filed together with an affidavit verifying the list of documents. In other words, an affidavit is a sworn statement. So the parties have to swear that these are the documents that are in their custody, possession, or power. So thanks for watching this video on discovery.